Hi, I'm talking with Mark Stephens. This is Bill Densmore with the Media Giraffe Project at the University of Massachusetts Amherst. I'm talking with Mark Stephens, who's an attorney in London, a British attorney, who represents some U.S. news organizations and also has some involvement with the WikiLeaks case, which I guess you can't specify exactly.
No, I'd prefer not to talk about that on camera.
But the reason why I want to talk to you for a minute is we were having an interesting discussion a moment ago about shield laws. You made a remark during a panel earlier this morning that you thought that the state of shield laws in the United States was significantly weaker from a journalistic perspective from the point of view of protecting sources than in most other European and sort of common law countries. So I wanted to explore with you an idea you were talking to me about a minute ago for how one might change the shield law landscape in the United States by using the Inter-American Court.
Yeah, I mean, the position is that international law has certain minimum standards, and the international minimum law standards in relation to protection of journalistic sources, America falls woefully short. They are parlous by comparison to the rest of the civilized world. And in those circumstances, I think it is possible to take a case to either a domestic court here in the US by saying international law, which forms part of US domestic law, means that there are shield laws in this country and we must apply them by virtue of our international law obligations. Or, if an American court won't acknowledge that, then in those circumstances you go to the Inter-American Court of Human Rights, which the USA is a party to, and then say, apply the international law standards on human rights for the protection of journalistic sources, and you will have imposed on the United States a new journalistic shield law standard. And the most important thing about that is that it will protect a wider draft of people, to include things like non-governmental organizations who are being pursued more vigorously by claimants these days, and it will also, I think, cover bloggers and people of that kind, because the question of who is a journalist today is almost a redundant one. It's people who supply information, and it's about the free flow of information. It's about the democratization, the transparency of knowledge.
So let me crystallize what I think you're saying. What you're saying is that were there a case in this country where a reporter is being threatened with jail for not revealing a source, that your argument, if you were counsel in that case, would be to say, cite as precedent international law, have the U.S. court hearing the case reject that, and then take an appeal to the Inter-American Court and have the Inter-American Court issue a ruling saying, look, you ignored a body of law that you're obligated by international treaty to acknowledge.
Yeah, effectively that's what I would do. I mean, I hope that the U.S. court would domestically acknowledge its obligations under international law. But this is how the shield laws in Europe have all developed, and they are starkly different to the ones that you see on the sort of state basis or state-by-state basis here. I mean, there was a case, Goodwin against the UK, which sort of really set the framework for it in the International Criminal Court for the former Yugoslavia. There's a case of Reynolds, and that was a Washington Post journalist who didn't have to be compelled to give evidence in a war crime. And similarly, there's just recently in the European Court been a case again, called Sonoma, against the Netherlands. And in each of those cases, the courts have built, reinforced, and held the journalist's right, indeed the public's right, to a free flow of information and to prevent the chilling effects which, if you have to disclose information and disclose sources, would otherwise create. And I think the Inter-American Court would pick that up with alacrity and say to the American government, you are in breach of your international obligations, you must come into line.
Thank you, Mark Stephens.
Pleasure.
Yeah.